Hi everyone, it's Gayani. I am back with a video about what's the difference between a provisional patent application and a non-provisional application or utility application. So non-provisional and a utility application, those are synonymous. I'm going to be using those both terms to mean the same thing, just so you know. Again, the disclaimer, I am a US patent attorney, so this is more information for US, and also this is for educational purposes only. If you have a specific question, please connect with the patent attorney. So a provisional application is actually what you call is a placeholder application. The reason you get that in place is sometimes you want some time to develop your product. You have more research and development to do, but you want to get the first filing. Remember, US is now under first inventor to file. So let's say you come up with the invention and you don't file, but somebody else independently have come up with the same invention and they file first, they have the first rights. So that's why you do want to file early. So you want to put the provisional application in place sometimes for that purpose, first to file. And it also helps you with the creating that priority date for any other things that the examiner may bring up. It could help in the patent prosecution process, some other applications, those things. But so the difference is with the provisional application, you usually don't need to have all the claims right, but I would highly recommend that you put in much of the specification together as possible, because whatever you want to claim the priority to this, when you file the utility, you want to claim priority to this provisional application, and you had to have the subject matter disclosed to get that date. Or you're going to have the new any new subject matter is going to be under the new filing date. So that's why you want to have as much you can, but at the same time, if you need more time to fine tune your invention, then this is a good option where you gather more data, and you could do more testing and all of that during that 1 year. So the provisional application only lasts 1 year, is not published, is confidential. But if you are meeting with investors, you could say patent pending, because you have filed the application. Sometimes when you file it, you may not have all the claims done, but you do want to have much figures, the drawings as possible for your invention. Because again, going back to it, when you file the utility, you may have to say, hey, that was not in the description, but it was included in the drawing. So you want to have much detail as possible. And the utility application, which you file within 1 year of filing that provisional application, is the one that goes forward and get examined by the USPTO attorney, who looked at it and say, oh well, is your invention patentable? Is it non-obvious? So those things are done for that utility application. So the provisional is just a placeholder, and it only lasts 12 months. And if you don't file the utility within that 12 months, you lose that right. So you do want to plan ahead and make sure that you could get the utility application filed within 12 months. And of course, if you already only need like 3 months, I would go ahead, file the provisional and file the utility in that 3 months. So it doesn't need to be we had to wait to file the other one. But usually I find inventors do like to take that time to develop the invention more fully and get more data and examples for your application. So I hope that helps you with the terminology, and if you're thinking about if you need a patent, it's give you an idea of your options. And again, if you like this video, please give it a thumbs up and subscribe to my channel, and thank you. Hope you have a great day.